fine, you can sit in your district court. This is my court, under the God Creator, the Lord. So I'm power of attorney, executive of state, so I order this case be dismissed, all complete and final. You have a good day, peace and harmony, your family.
Okay.
Thank
Now,
you
just
very much.
before you go, you're not going to be able to get too far with a police officer sitting there because there's an active warrant for your arrest.
Oh, okay, please go.
Okay, no, Murray. But we're not here to muck around too much. Let's see.
Yeah, if there's a warrant for my arrest, you can serve my warrant.
Just pause. I want to try and sort things out for you. I don't want this day to be a bad day. Let's see. I'll let you have a chance. Just let me have a chance. Whatever happens from today, you've still got this charge that you need to sort out today. You've still got community work that you're going to need to do. Unless you've been able to challenge and successfully appeal your conviction that resulted in that community work, is the sentence that you need to do, right? So, what are we going to do about this community work? What are we going to do about this charge?
You're on leases. But I told you, anything on legal fiction entity or corporation is a non-legal fictional entity.
I understand that. And
On my affidavit on the living man, please pause. In my affidavit, I say that I am the living man, special appearance and challenge jurisdiction. Now, jurisdiction must be proven in any court. District court, parliament, high court, anything. Without proof of jurisdiction, yeah, no standing.
just pause there. Just pause there.
No,
Just pause there. Just pause. Murray.
Because jurisdiction has not been proven, I require this matter to be dismissed, all complete and final.
I've heard you. You've said that 4 times.
There is no more.
You've said that 4 times.
There's no more peace and harmony upon me. I leave on my own free will.
Just
If he wants to come along, we can come along. Thank you. Have a good day.
Murray. Councillor, can you
You're going to have
enforce
to
that
go
right?
to those points. 8%. You're going to have to tell us what time.
Here's my copy. My copy.
Yeah, you got this.
Yeah.
That's where it's at. That's where we're going to stick it. Lead me up to it.
Yeah.
He's on the game.
Pins. Those pins.
61.
See what he's doing up there.
Yes, swaying them.
Just
There is also an application.
we want him to do like a maximum. You can only control
Well,
that.
we can at some stage today make a bail application, so it's a facility.
Okay. What was that one? Yeah.
West, has there been any progress on, thank you, Mr. English, I've signed that form, that's good.
You're right, that was made as a courtesy report.
No, and I appreciate that, thank you, your excuse.
Thank you very much.
Ms. West, any progress here on Mr. Boylan's?
Not that I've heard, so.
All right, if you hear anything before 11, let me know, we can convene court at any time to deal with that matter.
Will do so.
All right, nothing else we can usefully do until
You
then.
can stand up, stand up.
Thank you all of you.
Your Honour,
Yes.
uh,
I have a matter at hand.
I have a matter at hand. The papers have been furnished to the court. I have a further copy here.
Just bear with me, who are you?
All rights reserved, Gina.
Thank you, Ms. Gina. Let me have a look. A warrant was issued for your arrest, I think, this morning. Just bear with me.
All rights reserved.
Just bear with me a moment. Where were you at 10 o'clock?
I was here. Sorry, I
No, you're here now, that's it. All right, just bear with me a moment. I cancelled the warrant that was issued for your arrest this morning. Were you here when I was talking to Murray, the gentleman before you?
yes.
Okay. Did you hear what I said about the limitations you have on appearing in the district court?
Kind of. You'll just have to repeat that to me.
Okay. I saw from your file this morning that you filed similar papers that Murray has filed, protesting
Yes.
jurisdiction. Okay. The difficulty you have is this, that, and there have been many cases that have said this, so this is going to be the outcome today because I'm bound by that. But let me explain to you where it's all happening. You say that the legislation that creates the jurisdiction you're appearing in today is effectively unconstitutional.
No.
And that where that legislation is unconstitutional, that I don't have jurisdiction to find you guilty of any offence, let alone hold a trial in relation to any offence. The difficulty with running that argument here in the district court is that I do not have the power to strike down any legislation. I can't say. I can't agree with you because Parliament tells me what I can and can't do. All right? Parliament tells me that my job as a district court judge is only one thing, and that is to enforce the laws as they appear in the statutes. Now, if I disagree with the statutes, that's tough luck for me. If I think the statutes are wrong, that's tough luck for me. If I think Parliament had no power to pass a certain statute, that's tough luck for me. Because I, like you, at this stage, am bound purely and completely by legislation. If I disagree, or if any private citizen disagrees with that legislation, or if any private citizen like you thinks that anything is unconstitutional or that the district court doesn't have jurisdiction, there are only two ways really you can challenge that. The first is to go high up enough in the food chain to get up to the Court of Appeal or the Supreme Court, because they have the power to strike down legislation for being unconstitutional. Or you can lobby Parliament and get Parliament to agree that its laws are unconstitutional. But the difficulty is, Parliament tells me what my responsibilities are and are not, and courts above me issue judgments which I am bound to follow, even if I disagree with them. And courts above me have said, well, that's just how it's got to be in the district court. So there is the explanation that I gave to Murray.
Yes. Well, you are aware that I attend today by way of special appearance. I'll also remind you not to create joinder to myself and not to attempt to deceive me with trickery, spoken word or action into a foreign jurisdiction. Yes. Also, about the mention of citizen, I am a free woman, standing on the land, living, breathing. Acts, statutes, legislations are created by fictitious corporations. They're on the Securities Exchange Commission, registered. Also, to the maxim, you're aware of the maxim, you can only control that which you create. It is then that God created man, therefore man cannot control God. Man created government, statutes, acts, legislations, therefore man has jurisdiction and corporations. So I live under God's law, and that is the law which we should follow, not the law of man, which is statute law. And this is a common law court.
Where's the proof?
The People's Court. Otherwise, I'd like to see proof of this being statute court or jurisdiction. You have jurisdiction, I mean the courts have jurisdiction.
Where's the proof?
I'd like to see the proof.
Like I said to you, that decision is going to go against you, and let me just make a quick note of that right now.
Because it is a notice of default, dishonours, non-response and agreement of the parties. Lawful, notice of requirement for order of dismissal. Despite being afforded considerable latitude and more than sufficient time to respond, approximately 6 months, on the 10th of May today. I entered onto the record of the court this affidavit, notice of default, dishonours, non-response and agreement of the parties, notice of requirement for order of dismissal, for the attention of the presiding judge, court registrar, police prosecutor, to bring attention to the fact that there has been an abject failure to provide an affidavit of rebuttal to the affidavit as advised in point 1 above, which was point 1, page 1. Would you like a copy? I have a stamped copy here.
No, that's fine. And the other side don't need to put something in if they don't want to. Police don't have to respond.
You have to.
They do. They do. They must rebut anything on my affidavit because my affidavit stands.
They don't. What happens is if you come to court, you can if both sides get a fair chance to be heard, but either side can choose not to be heard.
They can't be heard. Fraud.
They can't be heard because it's fraud.
Okay?
They are operating under bankruptcy and insolvency, the police, New Zealand Police. So is the court system. It's registered on Dun and Bradstreet.
How can you have jurisdiction?
And, you know...
All right. I understand the argument. Go on.
We understand.
Okay.
Point 10.
page 2, number 3. Therefore, as of the 9th of May, 2017, no one pursuing the prosecution of the matter at hand has come forward to fulfil their lawful and legal administrative obligations, and amongst other aspects of lawful process have also subjected themselves to the maxim, he who leaves the battlefield first loses by default. 4. As an operation of law by dishonour of affidavit, this ultimate failure to respond has secured a full, complete and absolutely final default. Dishonours, non-response and agreement of the parties irrevocably to affiant's favour. Point 5, page 2. Said default applies to the prosecuting party and all officers, employees, agents, successors, nominees, and or assigns, as well as any and all other third-party interlopers, willingly and knowingly embroiling themselves as accessories after the fact, and henceforth also subject to all provisions and stipulations of the affidavit ab initio. Page 26. 4, and on the record, with the long overdue willful non-action in regard to prior notices as received, the prosecuting party have failed in their judicial responsibilities and have lawfully accepted that all facts and matters as delineated in the affidavit are permanently and fully agreed upon by way of tacit procuration in perpetuity. Res judicata, stare decisis, and subject to permanent estoppel by acquiescence due to their premeditated and intentional silence. Number 7. By providing inappropriate, non-lawful response or in remaining silent on the matter and in failing to act with lawful probity, the prosecuting party is fully cognizant of, have acknowledged and are totally willing to settle affiant's claim for tort damages costs, along with the conditions as stipulated in the time frame as contained within said affidavit. Page 2.8.
Just before you start on,
No, don't you?
how many points are
When
there?
you finish. Yeah.
Please let me finish. I'm still
I'll let you.
discussing
I'll let you.
law.
Just pause. I just want to know whether I should look at a copy of that after all.
Yes,
Copy of
yes,
that there?
I do.
Advisable.
It is the stamped copy.
All right. Thank you. Thank you. Just give me a moment.
Yes. All right, sorry.
How do you want me to address you?
You may call me.
You may call me Gina.
Gina? Just you. Helps you, Gina. It helps you, Gina. I've just read the identity affidavit a moment ago, so I don't need you to go through
Go through
the rest of
the
the affidavit.
I would like to go through because there's some points in here that matter here.
Yeah, by all means.
Okay. Where was I? Oh, 8.
You
Page
can't-
2.
Yeah. Hey.
Accordingly, the prosecuting party has fully accepted liability for tort damages as stated and are responsible for immediate and full settlement, unconditionally and irrevocably, of all associated outstanding and continuing monies owed, taking full effect from the date of tort damage brought about by their actions or lack thereof, being the 13th of October 2016. 9. It is again noted each and every party is jointly and individually responsible for the full amount of the base claim plus any and all accruals. Okay, I will just skip some of this and go straight to B. The last paragraph. Removal of judge for inability or misbehaviour, e.g. malfeasance of office. Also, just a point to 10b, the last paragraph there, over the page on page 3, top of the page. In the interest of clarity and for the avoidance of any doubt, it is emphasised that any judge attempting to circumvent proper due process and act in contravention of their oath of office is subject to the doctrine of ultra vires, acting contrary to and outside their scope of authority, wherein they lose all judicial immunity and protection from prosecution. As my witnesses will testify. So, this is what I'm here for. So, default and agreement of the parties, page 3, the last section. To reiterate and reconfirm this failure to respond in a timely and appropriate manner as prescribed at law, and now default is. As an operation of law, the prosecuting party's final admission and full and complete agreement to all statements and claims made by affiant myself through tacit procuration pertaining to the affidavit submitted. And the whole matter in its entirety is res judicata and stare decisis. The respondent and all officers, employees, agents, successors, nominees, accessories after the fact, third party interlopers and or assigns henceforth being in permanent estoppel through and by said failure to respond. Further, with regard to the damages, costs reiterated below, as advised in the affidavit and fully accepted and agreed to by the prosecuting party, settlement is now due irrevocably and unconditionally, term strictly 7 days from date of the lawfully established true bill invoice by way of affidavit of obligation. All words, details, constructs herein are as affiant defines them to be. Gina, Mary, Tino requires appropriate performance with regard to this notice of default. So I demand an order from the court that the charge is to be dismissed by way of estoppel, with all the stipulations of my affidavit to be adhered to, and for that to be full, final and complete in the matter. And my remedy.
Thank you, and very well spoken, Gina. Well done. face no charge of being partially controlled drug name cannabis plant in your possession. You can have a seat.
All right, Susie.
You have not at this stage entered a plea, but I'm sorry you have. A not guilty plea was entered on the 7th of November. The matter is set down today for a trial. You are self-represented. You have filed a number of very well prepared and thorough documents. You have spoken very articulately to those today, and you have done so with dignity and respect. In summary, your arguments amount to a protest to jurisdiction. I need not go through each of the documents that you have spoken so well to. Those are arguments that are well known to this court and the courts above. The district court is a creature of statute. Quite apart from what view any person might have about the district court's jurisdiction, its own jurisdiction is conferred to it by statute. To quote a maxim that you yourself have referred to this morning, for me to do anything that goes beyond what is contained in the district court empowering legislation would require me to act ultra vires. To quote a second doctrine that you have referred to this morning, higher courts have ruled on several occasions on exactly this issue. And that makes this issue res judicata, number one. And number two, because those decisions come from higher courts, I am bound by them. Accordingly, there is only one outcome that a district court can impose today on this protest to jurisdiction, and that is to dismiss it, because my jurisdiction comes only from statute. My powers come only from the statutes, other statutes requiring me to enforce those statutes. I have no power to strike down any legislation as being unconstitutional. And to put it very simply, the New Zealand Parliament has said that my one and only job today is to decide whether or not you are guilty or not guilty of possession of cannabis plant. I must therefore refuse what is, in colloquial terms, a protest to jurisdiction. That means that we will need to go ahead with the trial in terms, in a conventional sense. In other words, where the prosecution are put to the proof not to establish jurisdiction, because they don't need to establish jurisdiction, but they need to prove that you were in possession of cannabis and that it was a Class C controlled drug. I appreciate that you have looked towards today primarily as a challenge to jurisdiction. I don't know if you've turned your mind to the individual elements of possession of cannabis and supply. We will need to decide today whether or not you are guilty or not guilty of that charge. I don't know if you want to consider whether you still wish to maintain a not guilty plea. If you want some time to think about that, I'm prepared to give you some time to think about that.
Point on the record.
Just pause there.
All right.
I've given a decision, so you're not able now to make any further submissions on jurisdiction.
I am.
Just pause. Just pause.
No.
You're not. The only person that we can now make me have given a decision.
He is empowered by the common law.
Just pause. Gina.
Your court.
It's my court, Your Honour.
Gina, just pause.
On proof of jurisdiction, because this is a common law court.
Gina, I'll get you to pause for a moment, please. I don't want you to have a bad outcome today. Sir, I'll ask you to just be quiet because you are now really not helping Gina. Murray's already been arrested this morning. All right, this is not helpful. Gina, let me just do something now. I want to be blunt out, Gina. I want you to make sure that you do not get arrested. All right, just pause.
I'm here for notice of default, dishonours, non-response and agreement of the parties.
All right, we will let you in.
Ladies.
Ladies.
I will be bringing a charge against you, Judge, for your behaviour. I have witnesses here. I do not consent. I do not consent to anyone touching me. I do not consent.
They can keep their board, all there's is board. Everybody knows it. We'll be dealt with at a later
They're
date.
all operating under bankruptcy and insolvent.
Yeah, the truth.
How you people can support fraud the way you do, I don't know. You swear an oath to serve and protect and you go about damaging people from the get-go. That's great.
Thank you.
Yep, leave it at that.
I want to put a charge on that, Judge.
Yep.
So where do I do that?
I will give the document.
We'll go to Robin and get this document drawn up. What was his name?
We can go to the